Hey YouTube family, how you guys doing? I'm here with another video. Today we're going to talk about a man who was charged with a hit and run, and 3 years, that's not enough time. So we're going to watch this. I may skip through some things and then go to when the judge sentenced him, but we'll see how it goes because it's a pretty long video. So, okay, you guys, let me bring it to you. Just give me 1 second. Okay. All right. Let's go. Oh, shout out to News 5 in Cleveland. And also, you guys, if you could please like and subscribe if you're not subscribed. Share this video if you'd like. But yeah, let's get into it.
Good morning, everyone. We're on the record in 3 cases in order of offense dates. They are case number 695-091, 695-281, and 695-144. This is the state of Ohio versus Donald Minette, who is here for sentencing in those matters. His attorney is with him, Brett Jordan. Representing the state of Ohio is Tim Troop, Tom Revito, and also present with them from Cleveland Police Department is Detective Sergeant, Lynn Bilko. When we were previously here on March 20th of 2025, changes of plea were entered as follows. In case number 695-091, Mr. Minette entered a plea of guilty to an amended indictment of attempted domestic violence, a violation of 292302 and 2919.05. That's a felony of the 5th degree, which carries a possible prison term of 6 to 12 months in monthly increments, a fine of up to $2,500. It's a probationable offense. If a prison term is imposed upon release from prison, it carries the possibility of 2 years of supervision by the Adult Parole Authority on post-release control. Post-release control supervision is supervision that begins by the Adult Parole Authority when a prison term ends. If a person's placed on post-release control, they're required to report. Failure to do so will result in an escape charge, which is a felony. Non-compliance may result in sanctions being imposed, including being returned to prison in incremental periods of time for up to half of the original prison term. The named victim in that case, your sister, is Tamara Mirabli. My understanding is that she could not be here today. The state of Ohio did provide a letter, which will be addressed at the appropriate time in this proceeding. Also, back on March 20th of 25, you entered a change of plea in case number 695-281. You changed your originally entered not guilty plea to a plea of guilty to failure to comply, a felony of the 3rd degree, a violation of 2921.331B. That carries a Class 2 driver's license suspension of 3 years to life. It carries a possible prison term of 9, 12, 18, 24, 30, or 36 months. It carries the distinction that if a prison term is imposed in that case, by law, it must run consecutive to any other terms being served. On that date, March 20th of 2025, you entered a change of plea in case number 695-144. You entered a change of plea to count 2, a felony of the 3rd degree, a failure to stop after an accident, a violation of 4549.02A1A, which also carries a Class 5 license suspension of 6 months to 5 years. In each of these cases, you face possible post-release control supervision if a prison term is imposed for a period of up to 2 years. I'll note that in 695-091, that is, for the record, a re-indictment of case number 686-216. I will note that you were under a number of warrants for a number of your offenses, including 2 for which you are being sentenced, that being the failure to comply and the failure to stop after an accident. I'll address that further in a bit. Today, we're going to hear from the state of Ohio. I'm going to ask you initially if you've complied with the obligations imposed upon you pursuant to Mercy's Law.
We have it.
Thank you. And what that means is that anyone who's a named victim has a right to be present and heard. Mr. Minat, after we hear from the state of Ohio, they will present, if there's any representative of the victim who wishes to address the court, that victim representative, as they are entitled by law to do. I'll also read into the record the letter that I received regarding the domestic violence case.
First of all, he should look, 3 years, that's not enough. Okay. That's not enough for life. It's just not. And then I hear that he has other cases too. Okay.
Attempted domestic violence, excuse me. I'll hear from Mr. Revito as well. I'll hear from Mr. Jordan. If you wish to say anything, I'll be happy to hear what you have to say. At previous proceedings, I informed counsel that if they wished to have any documents submitted to the court for consideration for today's proceeding, to please get them in advance of today's proceeding to my bailiff, Mr. Dover. I have received the document that I previously mentioned regarding the attempted domestic violence. I've received no other documents. At this time, I'm going to turn it over to the state of Ohio. Thank you very much. Mr. Revito.
Thank you, Your Honor. So I will be addressing the first 2 matters before this court.
Thank you. Why don't we go by case number?
Turning to the matter CR 24-695-091, the attempted domestic violence incident. First, with respect to this incident, the relationship between the defendant and victim is that the victim is the defendant's sister. Ultimately, they got into an argument while the victim was in a vehicle. The victim and defendant were discussing his parenting style. Ultimately, the defendant reached into the vehicle and struck the victim on the right side of her face multiple times. This did cause some bruising to her right eye. She was treated by EMS on scene. Ultimately, she said the defendant also made threats against her. Over the course of the proceedings, I did reach out to her. Initially, she wanted to appear via Zoom for this hearing. Ultimately, she had a work conflict, but she did provide a letter to the court. With respect to the letter, for a brief synopsis, the state has a copy, defense has a copy, and you have a copy, but she was asking for leniency with respect to the attempted domestic violence matter.
These dudes that hurt their sisters are so trifling. Yo, if you're going to put your hands on your sister, you definitely going to put your hands on your girlfriends or any woman that comes around you. Trifling.
Turning to the failure to comply matter. So this is going to be 695-281. With respect to this matter, Your Honor, narcotics detectives were providing surveillance and ultimately saw the defendant get into a vehicle. They went to go stop the vehicle because of the aforementioned domestic violence matter. He had a warrant for that case, as well as a matter regarding the plate on that matter. They ultimately stopped the vehicle in an undercover vehicle using lights. While one of the detectives was approaching the vehicle, the other vehicle took off and almost hit another undercover CPD, Cleveland Division of Police cruiser. With that as well, briefly just looking over the defendant's priors as well, his criminal history before the Court of Common Pleas goes back to 2010. He does have multiple felonies before this court, including several attempted robberies, a robbery, but particular to these fact patterns, Your Honor, he had a DV in 2018 as well as a failure to comply in 2017. Ultimately, again, we're seeing this repeated conduct of behavior.
Why does this dude walk in the streets? Can y'all answer me that? Why?
Turn it over to Prosecutor Truman.
Thank you very much, Mr. Revito. Mr. Revito, I could at this time share for the record the letter received by the victim in the domestic violence case, the attempted domestic violence case, that being case number 695-091. The named victim is Tamara Marable, Tamara Marable. The letter indicates as follows: Your Honor, good morning. My name is Tamara Marable. I would like to sincerely thank the court for allowing the opportunity to have my voice heard. I am unable to attend the hearing in person. The letter in part says, I have forgiven my brother, and I truly believe he deeply regrets what happened. While I fully understand the seriousness of the situation and that the final decision rests with the court, I do not believe that jail time is necessary in this case. I respectfully ask the court to consider alternative options such as counseling, treatment, or rehabilitation services for Mr. Minette. I believe that with proper support, he can continue making positive changes in his life and stay on the path of healing and growth. Thank you for your time and consideration. This will be marked as a court exhibit as part of the record. Thank you. Mr. Troop.
Thank you, Your Honor. Your Honor, in regards to 695144, on August 16th, 2024, 7-year-old Amir Pruitt was riding a skateboard in an apartment housing community on Lakeshore Boulevard. Tragically, Amir rode that skateboard into the street where the defendant was driving a Mercedes SUV at a slow rate of speed. Amir rolled, according to the video surveillance that we have, right under the wheels of that SUV, and his life was taken. This defendant turned around in a parking lot and sped back directly past Amir's body. He drove his SUV just a short time before dumping it. It was located by Cleveland Police Department shortly later. Approximately 3-week manhunt ensued. The U.S. Marshals Violent Fugitive Task Force apprehended the defendant. He was hiding in a storage unit out in Lake County when they located him. The accident investigation unit from Cleveland Police compiled the investigation on this case. They took information from the black box on the SUV. They obtained surveillance videos. City cameras were used in the investigation as well as license plate readers and statements from several witnesses at the scene, as well as Mr. Minette's passenger at the time. Amir's mother, Rayshonda Macklin, is present in the courtroom and would like to address the court.
Thank you, Mr. Troop. Good morning. I'm Joan Sonnenberg. I'm so sorry to meet you under these circumstances. Ms. Macklin?
I could just read it. Hang on.
Take your time. This is Rayshonda Macklin.
On August 16th, I feel like my life ended. When I got the call and my son had been hit and dragged and left in the street. When you hit my son, you dragged him in as bystanders yelled and told you that you hit a kid. You just left him there like he didn't matter. He mattered to me, he mattered to his father, he mattered to his sister, and so many others that are here today. The pain that I endure would never go away. Every day, my daughter asks about or mentions her brother. How she missed him, how she wanted him to wake up from his sleep. I'm a very understanding person, and I understand that accidents happen, but I'll never understand why you would feel like it was okay or ever justifiable to leave my 7-year-old son in the middle of the street, dying. You didn't even give him a chance to live to see if he would make it. You chose to keep going, and at that point, it was no longer an accident, but it was a choice. You chose to leave him there and fight for his life. And to taunt me on Instagram, telling me that to leave you alone and that it wasn't you. You hit and you killed my baby, and you'll never know how much hurt and pain you caused, not just to me or his family, but to so many kids who was out there and had to watch what you did to their friend. I can't close my eyes without seeing visions of my son like that, all bloody with his head open. I have images of my son that a mother should never see. Thanks to you, I don't feel like you deserve to take a chance, because ultimately the decision will be left in the hands of the judge. I just hope she gives no leniency when sentencing.
Yeah, that is so heartbreaking. I just can't even imagine. Although I did have a cousin who was ran over by a metro bus, and his mother, my aunt, had to see her baby's head smashed from those big tires. He was 12, and I'll never forget it.
So very sorry for your loss. Thank you for your time today. My deepest condolences to your family.
Thank you.
So sorry. Thank you.
Your Honor, the purposes and principles of sentencing are to protect the community and to punish the offender. Mr. Revito highlighted the defendant's criminal history. It goes back on felony cases to 2010 when he was bound over from juvenile court on a robbery case. Multiple felony convictions, multiple violent felony convictions. Mr. Minat has been either under indictment on serious felony cases or incarcerated for approximately 15 years. There is no defendant that the community needs protected this court more than Donald Minat. Further, this offense, the failure to remain at the scene of an accident, while we recognize that Mr. Minat is being sentenced for his actions after Amir Pruitt lost his life, we believe this is the most serious version of this offense. A child's life was taken. Mr. Minat went on the run. This case was well publicized. He knew that a child's life had been taken, and yet he fled. So we feel that this court certainly has evidence and facts before it that would call for a serious sentence to be imposed on these three cases. Thank you. One more thing to add, if I may, Judge.
Sure.
I have confirmed with the detective in our databases, the defendant did not have a valid driver's license at the time of this tragic crash, and he was not on first release control.
Thank you. Is there any information on the release date from the last day Mr. Minat had in the Department of Rehabilitation and Corrections?
We've tried to search the databases, Your Honor, and we're not coming back with any information. Certainly, I could provide it to the court at some point when I get access to that, but we don't have it.
I know it could not have been before May of 2022 because there was still some programming going on in the penitentiary that he was participating in. Perhaps I can find out in a moment. Thank you very much, Mr. Troop. If there's anything further, please let me know.
Thank you.
And we'll hear at this time from the defense, but I do want to thank Ms. Matham once again for her time and offer deepest sympathies to you and yours. Mr. Jordan.
Thank you very much, Your Honor. Your Honor, in answer to your question, is my understanding that my client was released at the end of May of 2022, and he was not placed on PRC. Your Honor, to address the cases that have been addressed in order that they have been already addressed, with regards to 695091, as you have seen and read from the victim in this matter, that she has acknowledged that he has deeply regretted his actions, and she understands that counseling and treatment would be very, very beneficial to Donald so that he can stay on a path of healing and growth. She has forgiven him, and she again acknowledges that he has remorse for his actions. Judge, with regards to 695281, the failure to comply case, Judge, I have seen the video with regards to this particular matter. He pulled off after being stopped. did make a left turn in front of another police vehicle. It was not a very close, almost striking the other vehicle. There was room. And Judge, what I'd like to point out from here is, as in most failure to comply, there's usually some kind of chase to apprehend the person. In this particular matter, there was no chase. There was no indication of any high risk of high speed. There was no other indication of any other risk to the community after that.
Sir, all that doesn't matter. He ran. He left the baby in the streets. That is all the point is. But defense attorneys got to do their thing. You know, that's their job. So let's continue to listen to the excuses.
What we have here is he got away from the actual stop itself, and everything in essence stopped after that. Obviously, he kept on going, but I would assert that there was no one chasing him. There was no need to be driving or putting anybody else in danger throughout the rest of it, as there was no chase. Judge, I would assert to the court that it's actually the least serious of this particular offense. As you know, we have many other cases where there's high-speed chases through neighborhoods, running off multiple stop signs, multiple traffic lights, in and out of traffic, on the other side of oncoming traffic. This was not that case. Lastly, Your Honor, with regards to 695144, first of all, I'd like to express my personal condolences to Amir's family and friends who are here in the courtroom. This was an incredibly tragic situation, and I'm sorry that it happened.
Hey, y'all. Excuse me. Peep the cop in the back.
And I'm sorry that Amir is no longer with us. Judge, again, in this particular case, my client was operating the vehicle at about 5 miles an hour.
He lied.
Unfortunately, Amir was on a skateboard. My understanding was he was lying flat on it and rolled into the street.
So
Afterwards, my client did turn around and came back towards where Amir was. He did not stop, and that was a bad choice on his part. However, at the time, Your Honor, there were multiple people outside. Multiple people ran towards Amir to help him. I can't give you a count, but I would say it was some in the neighborhood of 10 people were out there, and they're on the scene. And I mentioned that, Judge, not as an excuse, not as anything but an explanation. At that time, we made the decision to continue on, knowing that other people were out there, and he was, quite frankly, afraid of what would happen to him had he stopped.
Excuses. But like I said, he's a defense attorney, so he's got to do his job. But he don't like saying all this because you can just tell he don't like doing this. He can't.
Judge, with regards to his actions afterwards, I will let the court know that he did contact my office. I was, I believe at the time, out of town and or going out of town the next day. We were trying to make arrangements to voluntarily turn him in. However, prior to that happening, he was found and arrested at that time. So I will let the court know he had all intentions in turning himself in. And I can say that because, again, he did call my office and we were trying to make those arrangements. We did not get it done.
I'm going to ask for there not to be any conversation, folks. I know this is a tough time, but if you would kindly just let us proceed here, it would be greatly appreciated. Thank you. Go ahead.
And again, it's just, again, my client will speak here today. He is very remorseful for everything that has happened. Judge, he has done 7 months in the county jail. He's had time to reflect. He's had time to think about self-improvement. Your Honor, understanding that all of these offenses are probationable offenses. His last case were in 2019, some 5-6 years ago. He did serve a 30-month sentence then. Judge, I would ask that the court would consider a community control sanction, as he has been very remorseful, as he has spent the last 7 months as punishment in the county jail. Should the court find that community control sanctions are not appropriate in this particular case, I would ask the court to impose a 9-month sentence on 695-281, which is the failure to comply. As I stated earlier, that I believe that this was the least serious of that type of offense.
What about the death of that baby? What about that?
And with regards to 695-144, I would ask the court to only impose a 1-year sentence on that. Again, the crime itself, as the court is well aware, is that he did not stop after the accident. And we understand that that is a very serious crime in and of itself. But we ask that you consider a 1-year sentence on that. Thank you.
You're welcome. Thank you. Mr. Minot.
I really don't want to say too much. I just want to apologize to the family. I ain't mean for it to happen.
So I'm going to ask you to direct your comments to the court. Mr. Minot, if you have something to say, please say it to the court.
I just wanted to apologize to her because I didn't mean for that to happen. I didn't know what happened. When I turned around, when it actually happened, I didn't know what happened. When I turned around, the passenger of my car, he told me, I think you just hit a little kid. So when he said that, as I'm turning around, I'm looking and seeing what's going on. And when I see a lot of people right there, I didn't know what to do. I was scared, so I just drove away.
That's the crime.
Yeah, and I know that, and I don't even want the court to even be lenient on me because I did something wrong when something happened to her family. I ain't mean for nothing to happen to her son. I didn't know that. I didn't know what was going on. When it happened, I didn't see the little boy. I seen the kids ride past my car. They went past my car. I slowed down for the kids to come. They was on bikes and bring them past the car. I didn't see him. And I started driving and I hit him. I didn't know. So when I turned around, the passenger told me, I think you just hit a little kid. So I drove away. And when I drove away,
And that's the problem. If somebody said you hit a little kid, you should have stopped and went and saw what you did. If that was your child, how would you feel?
I went and took the passenger where he wanted to go. I called Brett's office. Brett's office, and he wasn't available. And I talked to him Monday, and he told me he was on his way out of town, and he would handle it, and we would be turning ourselves in. So I was just waiting on that because I knew I did something wrong, and I didn't know what to do after that. I just didn't know what I was supposed to do. After I already ran over a little kid, I didn't know what to do. I got kids of my own, so I didn't know what was going on. I didn't know what to do. It had been times I've been here and I had dreams about me doing that. So it's I don't know what's going on with myself. I don't even know how I'm gonna be able to like continue with life, knowing that I did something like that. Like I had to tell my children that I did something like this. Like I disappointed everybody that I know by doing this stuff. So it's like I'm not asking the court to do anything special for me. Like I just wanted the court to let me apologize for what I did because I really didn't mean to do that. Like it was an accident. But I understand. I didn't even know that it was against the law to keep going. I didn't.
Oh, yeah.
I really didn't know that. But now I do, but I didn't know what to do.
What about humanity?
Mm-hmm.
Like I feel like
What about the laws of humanity?
I feel like
You're a father of, last I knew, as of 2019, 5 kids. And what you just said to this court, I hit a little kid, so I drove away.
I was scared. I ain't gonna lie, Your Honor.
I understand that. It's about,
I thought people was gonna do something to me if I was, because I know if somebody would hit my little kid, I wouldn't try to do something to them right then and there. I wouldn't have been like, oh yeah, let's call the police. I would have tried to do something to them. So that's what I thought was going on. And I'm not gonna lie.
Should have got your ass whooped
Stay
then.
right there. I wouldn't be right here in front of the court right now.
Should have took that ass.
unless you have anything else to say.
No.
Nothing further. Thank you, Ken.
Thank you. In any felony sentencing, there are purposes and principles that are statutorily directed, which is to punish, to protect the public from future crime by the offender, and to promote effective rehabilitation, if that can be done reasonably. In determining how to achieve those goals, the court is required to consider the category of recidivism and the category of seriousness. Recidivism means the likelihood of someone offending in the future. To achieve a determination of whether you are likely or unlikely to reoffend, there's statutory guidance given to a court. I've considered those factors, and what indicates that you have a very high likelihood of reoffending is your criminal past, as well as your adjustment to any kind of penalty, your history of disregard for others, your history of non-appearance in court, non-compliance on sanctions, and fleeing from any sort of justice. I did review a pre-sentence report that was prepared at the direction of another judge formerly of this court when you were sentenced for the last time that you went to prison, which was on 5 separate felony cases. Those cases included case number 622007, which was a felony possession of drugs and attempted conveyance of drugs, 623559, which was a failure to comply with the order or signal of a police officer, a felony of the 3rd degree, and a felony of the 4th degree of receiving stolen property of a motor vehicle that had been stolen at gunpoint in Cleveland Heights. Case number 623956 was a domestic violence, a felony of the 4th degree, also aggravated menacing. You ultimately served time on all these cases, but I'll note that the domestic violence carried a mandatory sentence because the victim, who was your girlfriend, was pregnant, and the law requires a mandatory term. In case number 626442, you pled guilty to attempted robbery as amended for a robbery that, according to the pre-sentence report, included firearms of a barbershop.
Do you guys hear all these charges? Do you hear it? And this title says man sentenced to 3 years in prison. What?
In case number 632515, you pled guilty to a felony of the 3rd degree of having a weapon while under a disability, also possessing crack. You had an active felony warrant at the time. According to this pre-sentence report covering those 5 cases, the date of which of preparation was July 18th of 2019. At that time, you were well known to law enforcement, including Cleveland Police Department, the Ohio Department of Public Safety, and Euclid. You were known to be a member of the Lakeshore Boys Gang or Lakeshore 6 Boys Gang. You were known to flee apprehension by law enforcement, as a historical note in the pre-sentence report. As of July 18th of 2019, you were the father of 5, who today would be ranging in age from 6 to 18. That further revealed that you were shot in 2012. At the time of the preparation of this report, there were outstanding warrants for you out of Wycliffe for drug offenses. You have multiple driving license suspensions, and I'll note that at the time of the offense involving Amir, you didn't have a driver's license. Your driving privileges have been suspended at least 25 times as of the date of the 2019 pre-sentence.
Hold up, y'all. Hold up. How do you get your license suspended 25 times and still have a license? Well, yes, it got taken or whatever later, but maybe after the 5th or the 4th or like 25. Are you serious? You can't be. This guy, her reading this record off it's cringy. It's cringeworthy. It's just, I don't understand the justice system. And this is why I watch these cases, because the justice system is not doing the right thing at the right times. Okay, we got to wait for this tragedy, and then you just give them 3 years. We'll see. I can't. It says sentence to 3 years, but I could have sworn it was more than that. But there's going to be a part 2 because this one's kind of long. So the sentencing part, like when she actually like throws the hammer down, that will be in another video, my next video, and that one's only like 18 minutes long. So yeah. All right, let's continue with this trifling record.
You indicated in that report being a heavy alcohol user from the age of 15,
Oh my
a
God.
heavy pot user, referring to daily for each of these, from a younger age than that, I believe 12. As of the age of 15, a daily ecstasy user. As of the age of 20, a daily K2 user. As of the age of 23, a daily opiate user. And as of the age of 25, a heroin and crack user.
What?
Daily. Are you now 33 years old?
Hold up.
I heard the state say your record goes back.
Hold up. He's doing crack and heroin and all those other drugs. Yo. I
believe your record goes back 20 years. I'll get to that in a moment.
He looks pissed.
So this indicates a history, and as referred to earlier by the state, a history that includes similar charges to what you are being sentenced for today. Back to the recidivism issue. Having a criminal history is a likelihood of reoffending. Having an adult or juvenile criminal history so indicates. Not complying on probation is another indicator. Having a substance use issue that is unaddressed is another issue. Expressing remorse is to be considered when it comes to recidivism. I heard you say you didn't know what you were doing. You knew you left. That's the crime here. And you made it very clear. You left because of fear of repercussions and consequences by law enforcement or a court system. I did consider your criminal history, and it is extensive. I'm going to place it on the record because it is a factor I must consider in determining whether you are likely or unlikely to reoffend. At the age of 13, 2004, you were found delinquent of attempted grand theft of a motor vehicle. You were placed on community control. That was December of 2004. May of 2007, you were adjudicated delinquent of attempted receiving stolen property. August of 2007, you're placed on probation in juvenile court for attempted possession of criminal tools and criminal damaging, violated that supervision twice. You were found delinquent of aggravated rioting in 2007, December 2007. March of 2008 in juvenile court, there was a matter that was bound over that was felonious assault and robbery. In juvenile court in 2008, you were adjudicated delinquent of drug possession. In 2009, in juvenile court, you were adjudicated delinquent of robbery. There was a suspended Ohio Department of Youth Services commitment. You were placed on probation. You violated at least one time. You appeared in court over the period of about a year and a half on that matter. You were adjudicated delinquent of theft in 2009 in juvenile court. That was September. October of 2009, charged in the juvenile court of kidnapping and robbery was transferred to the General Division of the Cuyahoga County Common Police Court. In 2009 in Common Police Court, you pled guilty to robbery. You were placed on community control sanctions. You violated twice. In 2010 in Stowe Municipal Court, you were convicted of obstructing official business. There were warrants issued for you twice. In 2011 in Cuyahoga County, you were convicted of attempted robbery. A warrant was issued about a month after your change of plea. You were ultimately apprehended and sentenced to the Cuyahoga County Jail for a period of 6 months. August 2011, Stowe Municipal Court, drug possession and obstructing official business. You were convicted. There were warrants issued for non-appearance. Those warrants were recalled in 2014. In November of 2012, you pled guilty to attempted robbery. You received 17 months at Lorraine Correctional. In 2017, Euclid Municipal Court, you were convicted of drug abuse. In October 2017, a case out of Euclid in Cuyahoga County Common Police Court, you pled guilty to drug possession and received a 10-month sentence at Lorraine Correctional. In 2017, that would be November, a case out of Lyndhurst. You pled guilty to failure to comply with the order or signal of a police officer, a crime you're here for today, and received a 15-month period of incarceration at Lorraine Correctional. December 20th, 2017, you pled guilty to domestic violence, a crime that you are being sentenced for today with the attempt statute, received a mandatory period of incarceration of 6 months. In February of 2018, you pled guilty to attempted robbery and received a 15-month term at Lorraine Correctional. In November of 2018, you pled guilty to a weapon under disability and received a 9-month term of incarceration at Lorraine Correctional. Anyone who goes to prison generates an institutional summary report. I reviewed yours. There's over 40 write-ups. Many of them are just for refusing to do what you're expected to do, ordered to do, signed up to do, as well as bringing contraband in, organizing for contraband to get brought in, that being drugs, through balloons and other means. When there were shakedowns of your cell, there was contraband found.
Wow.
I would consider this adjustment to be negative, meaning not good. Today we're here to address those purposes of felony sentencing that I mentioned before, of punishing, protecting the public from future crime by you, and promoting effective rehabilitation. I have reviewed the same seriousness factors that I heard referred to by both the state of Ohio and your attorney. And after considering those factors that indicate your conduct is more serious and listening to everyone who I heard today and considering 2921.12b, I find that your argument is not persuasive, Mr. Jordan, and that in fact this crime is extremely serious. When it comes to considering factors that would indicate whether you're more or less likely to reoffend, as I just explained by the record, the clear pattern that has been established over 20 years, and your desire to put you first, you are dangerous in our community. You are dangerous. It just is inhumane, especially as a father of 5 kids as of 2019, that you hit a little kid who's out being a little kid playing and you leave because you're concerned about the consequences that you have, because once again, you're offending our community with an outstanding warrant. So you do what you always do. You took off. And then you continue to do that as law enforcement looked for you and found you cowering in a storage unit.
Tell him, Judge.
The crime was that you left. This is like humanity versus depravity. Your sister who wrote the letter believes that with proper support, you can continue making positive changes in life and stay on the path of healing and growth. I haven't seen those changes, and I haven't seen anything to indicate that path.
Tell him, Judge.
Those are the findings with respect to recidivism, with respect to seriousness. If you wanted to turn yourself in, you know how you can do it? Go to a police station. It's not about the miles per hour. By the way, driving once again without a license, no respect for even taking to the roadways. For years. This is not about what Amir was doing. This is about that you left, which is what you do, your fear of consequences. In case number 695281, that is the failure to comply. I'm imposing a 3-year term at Lorraine Correctional. That is the maximum term. In case number 695144, also a felony 3 that carries the same penalty, I'm imposing a 3-year term. By law, those sentences must run consecutive. As I mentioned earlier, that is a requirement with the felony 3 of failure to comply because of the seriousness it poses to everyone in your path. Considering what your sister had to say, in case, it's consecutive 3-year terms in 695281 and 695144. In 695091, upon completion of your 6-year term, you'll be transferred to the county jail to await placement in a community-based correctional facility. That's the case that carries 6 to 12 months. You're required to complete the entire CBCF program, which is a lockdown facility, in the hopes that you can gain some tools before you regain any kind of liberty and join our society, hopefully as a productive member who doesn't go out and hurt people or just put yourself first. You do face possible post-release control supervision for a period of up to 2 years. Costs of these prosecutions are assessed. Please be advised that you will receive credit for time served. The sheriff will calculate, but my understanding is that it's 218 days. Your license is suspended in case number 695281 for life, and 695144, it is suspended for 5 years. Is there anything further on behalf of the state of Ohio? May I see council sidebar briefly? Thank you.
Okay, we're going to pause it right here. There's a second part to it. If you're interested, please tune in. I'm going to look at it first to make sure it's not a repeat, but I don't think it is. I believe it's something different. But yeah, y'all. Sad, sad case. So let me ask you guys this. What do you think his sentence should be? What do you think his punishment should be? What do you think about all those prior cases on this dude? I don't know. I think he deserves more time. 6 years is not enough. But hey, I'm not the judge, and I'm just a citizen. So anyway, you guys let me know what you think on this video and what exactly he deserves. Okay? All right, y'all. Thank you for watching. Please don't forget to like, share, and subscribe. Alrighty, guys. Let's see if I can do my outro video. I'm not sure how it works, but we will do it.